What is common between Rhea Chakraborty, Nawab Malik, Robert Vadra, Vijay, Mallya and Rana Ayub? It is actually the Prevention of Money Laundering Act and an ED probe. In fact, Nawab Malik's arrest by the ED last week has brought the spotlight back on this law, and that's what we'll be talking about in today's episode of KYC or Know Your Constitution. Now, this law was brought in 2002 by the NDA government to prevent money laundering. As we know, the ED, Directorate of Enforcement, is a financial investigation agency under the central government's Department of Revenue, responsible for enforcing the provisions of the PMLA, the 2002 Act. And it is the same ED that in 2020 had questioned Rhea Chakraborty for 8 hours in connection with the money laundering case, which we know was related to Bollywood celebrity Sushant Singh Rajput's suicide. And it's the same ED that last week arrested NCP leader and Maharashtra Minister Nawab Malik, investigating an alleged property deal that he entered into with Hasina Parker, sister of underworld don Dawood Ibrahim. But the constitutional validity of this law and the ED's powers are under challenge in the Supreme Court. The court currently has nearly 200 petitions on powers of specialized agencies like ED and Directorate of Revenue, and more than 80 of these deal with PMLA, these petitions. These include petitions filed by several politicians accused of money laundering, such as Lok Sabha member Karti Chidambaram, former Punjab MP Sarwan Singh Philor, and former Jammu and Kashmir CM Mehbooba Mufti. So it has a lot of these big names involved. And in the back-to-back hearings, several important arguments have been raised before a 3-judge bench of the Supreme Court. On one hand is the entire debate around how serious the crime of money laundering is. During one of the hearings, the court pointed out that the country's economy is the ultimate victim of such a crime, and so this affects every citizen. In fact, during one of the hearings, the Supreme Court said that money laundering was a more serious crime than murder is, because it affects the entire economy, which gets derailed because of it. And on the other hand, senior advocates like America Guruswamy have raised some very persuasive arguments on how the law is actually misused. For example, a finance ministry report showed that while ED conducted 1,700 raids and launched special investigations in over 1,500 cases between 2011 and 2020, it secured convictions only in 9 such cases, which is a very small number. So of course, lawyers for various petitioners have argued that PMLA is often invoked against political rivals or dissenters because the process itself becomes the punishment. And how does that happen exactly? Because of how strict the provisions of PMLA are. We often talk about how provisions of UAPA, Unlawful Activities Prevention Act, are, but if you see PMLA, you'd notice how these provisions are no less. For example, take the fact that the Enforcement Case Information Report, ECIR, which is equivalent to the FIR, First Information Report, is considered an internal document and not even given to the accused. So the accused doesn't even know what the allegations against him are. In fact, during one of the hearings, senior advocate Kapil Sibal told the court that PMLA has become Frankenstein's monster and called it a Belagam Ghoda, or an unbridled horse. Then the Indian Evidence Act says that any confession made to a police officer cannot be used as evidence against the person making the confession. This was, as we know, done to make sure that the police does not end up abusing their power or using third-degree torture methods that you've often seen in movies to extract confessions. But Section 50 of the PMLA allows an ED officer to summon people, ask them to submit documents, etc. And when a person is summoned under this provision, they are bound to state the truth and produce the documents that they are asked for. Basically, it's compulsory, mandatory to the extent that if they even refuse to answer any question or refuse to sign any statement or don't turn up when they are summoned or don't supply the documents that they are asked for, they can be fined for it and liable for prosecution under Section 63 of the Act. So Sibal has now argued that under this provision, an officer of the ED can legally require the accused to sign a confessional statement, failing which he can be prosecuted, like I mentioned. He argued that such a scheme fails to recognize the fact that threat and coercion are bound to exist when a person is either interrogated or in the custody of the ED. For context, you should know that Section 313 of the Code of Criminal Procedure makes sure that even the court cannot compel an accused to answer its questions under threat of sanction or under oath, but PMLA allows it. So he asserted that the provision violates Article 23, 20 subclause 3 and 21 of the Constitution, Article 20 subclause 3 says that no accused can be compelled to be a witness against himself. What does this mean? Basically, courts have held that this is why an accused cannot be compelled to undergo narco analysis, polygraph, brain mapping, saying that this compels them to give evidence against themselves, which violates their rights. As for Article 21, it guarantees the right to life and personal liberty and also includes the right to fair trial. So in short, ensuring that Article 20 is not violated also comes under ensuring that the accused gets a fair trial, so they are closely linked. Now there's another catch. Since the ED is not a police agency, statements made by the accused to ED members in the course of an investigation can be used against the accused in judicial proceedings. So now, petitioners have said that since ED exercises police powers, they should follow the safeguards under CRPC, which it doesn't at this point. Apart from this, there's finally also the bail provisions under PMLA. It is extremely difficult to get bail under this law. Section 45 says that the court needs to have reasonable grounds to believe that the accused is not guilty and that he is unlikely to commit another offence while he is out on bail. The bail provisions under UAPA, which has been the talking point over past few years owing to its stringency, that does not have such a precondition, but this law does. Now, petitioners have said that this takes away the presumption of innocence that is usually afforded to accused persons under criminal law. To be granted bail, the accused under this law must prove that prima facie they were not guilty and satisfy the court that they will not commit any other offence. These twin bail conditions, in fact, are central to this case. And this is why ED has been under criticism by a section of people. That's all I have for you right now. This is Apoorva Mandhani for ThePrint. Hope you enjoyed this video, and for more such content, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.